to the admissions process and delving more deeply into that. Now, hopefully this will be a useful general guide to applying to study law and indeed the benefits of studying law at university. As you've heard, I'm the admissions officer for the law school at the University of Kent. Now, what I can give you is some information that will hopefully be a useful overview of the broad position of law schools and universities on these subjects. But I'm very aware that I am one admissions officer and that other admissions officers at other institutions may have slightly different perspectives to me. Now, I think that the information I'll be providing will be it is generally uncontroversial and should be fairly broadly accepted, but I am very conscious that when we come to, in particular, discussing aspects of the application, such as the personal statement, this is a view I can only really express the views of the law school at the University of Kent, although I hope that this presentation will be much more broadly useful than that. So just to say a little more about who I am. I'm the admissions officer at the law school at the University of Kent. We're a large and well-respected law school. We have just over 1,000 students, and of our undergraduate students, over half are from outside of the UK. So we have a large student body and students from all over the world. I have a long career in university admissions. I've been the admissions officer in the law school for just over 10 years. And although I'm not an academic member of staff myself, I work with a team of academic colleagues, including our Director of Studies, our Director of Learning and Teaching, and our Head of School, to make decisions on applications from applicants around the world. I review with colleagues hundreds of applications per year and have been doing so, as I say, for many years. So that's me. I'd like to turn to our first poll just to find out a little more about our audience and just find out a little more about you. So the first question I'd like to ask you today is, what is your role in working with and advising students? Now, this should hopefully open a poll on your screen, which should allow you to make choices. If you do so now, that would be super. Great, numbers are appearing before me, so I'm viewing that as a positive sign. Okay, so I can see that everyone's voted now, and the majority of you who are viewing, just to give you all a sense, are careers advisors, with some people who are in attendance who are also school and college UCAS coordinators, and others who are have a different role, quite possibly in teaching. Now, moving on to the substantive secondary aim of this presentation, just to give you an overview of law at university and the benefits of studying law, I thought I'd just ground the subject broadly to give you a sense of its availability and to some extent its competitiveness. Now, it's probably no surprise to hear that there are a wide range of universities that offer law degrees. There are 108 universities according to the most recent Guardian league table, and law is a popular subject. Again, I'm sure that's no surprise to you all. It was actually the most popular individual subject for the years 2012 to 15, which is the most recent for which UCAS published data. You'll be able to see all of these slides afterwards, so hopefully you can click and interrogate that link should you wish to. But law is a popular subject which many students choose to study every year. Law also has a reputation as a competitive subject. Now, I'm afraid that the last point on this slide is rather wonky maths, so I'll explain it and explain what I was hoping to convey from this. You'll see that this data is really, this is why it's wonky maths, it's pulling an average. It was averaging effectively the tariff entry as displayed in the most recent complete university guide for all law schools in the UK. So it's not taking account of each individual student, it's just taking account of the tariff score for each institution. You'll see that overall the average tariff for each for law is actually very similar to the average for all subjects, but the tariff required for law is higher at the top end. If you look at the tariff average for the top 30 institutions who offer law in the Complete University Guide. The tariff requirement is 14 points higher than the tariff average for the top 30 universities just in the overall Complete University Guide standings. I don't want to dwell on these points, and as I say, this is rather dodgy maths that I've employed, at least for the final point, but what I wanted to really do in this slide is just to reinforce your probable expectations. Law is a subject which is widely available, is popular, and overall, certainly a better institute or higher ranked institutions is competitive. Now, moving on to the reasons that students choose to study law. I've split this in two, really. There are many reasons that students choose to study law, but I'm going to choose one which is commonly expected and one which I think I'd like to suggest is perhaps more important. Now, again, it will come as no surprise to hear that, certainly anecdotally and from research, one of the primary reasons that students choose to study law at university is because they are interested in a career as a lawyer, as a solicitor or barrister under the current split profession that we have in the UK. Again, I don't want to dwell on this too much, but I've just provided here a slide which gives a broad overview of the qualification process for people who wish to qualify and practice as lawyers. As you'll see, under the current structure, which is regulated by the legal profession, one of the steps can be either to study a qualifying law degree, that is an academic law degree which is validated by the profession, and most law degrees in the UK are qualifying law degrees, or to study a degree in another subject, say English, maths, or really any other degree, and study a one-year conversion course currently called the Graduate Diploma in Law. That, under current regulations, completes the academic stage of qualification before students then go on to pursue a one-year bar professional training course if they wish to become a barrister, or legal practice course if they wish to become a solicitor, before then pursuing in-employment training, which is not something which is widely available, it's competitive, before then ultimately qualifying as a barrister or solicitor. Again, I don't want to go into a great deal of detail here, but I wanted to make clear that under current regulations, law degrees, qualifying law degrees, as most law degrees are a firm part of the process for students who wish to qualify as a lawyer, should they wish to take that route rather than studying another degree and then doing the graduate diploma in law. However, it's important that I add that this is all subject to change. Now, again, this could be a webinar in itself, but it's worth mentioning, certainly if you are involved in advising students who may wish to go into legal practice, it's worth you being aware of this as well, that the professions are currently reviewing legal education and training, every stage of it, including the role of the law degree in the qualification process. Now, when I say the legal profession, I mean the Solicitors Regulation Authority, the SRA, and the Bar Standards Board. Both are undertaking independent reviews which may reach independent conclusions. The Solicitors Regulation Authority are further ahead in their review, and they are, just for information, proposing that professional qualification be removed from law degrees entirely. Now, this may or may not come to pass, but it's certainly worth being aware that the current system of qualification is currently under review, and that although a law degree has never been a necessity for people who want to go into legal practice, it's the requirement for a law degree may lessen if future changes come to pass. Now, again, I don't want this webinar to become about this, but I'm very happy to answer questions on this at the end of the webinar should people have them. Now, the next reason I would like to suggest that that students choose to study law, and certainly complementary to the first reason, is because law is a wonderfully interesting subject. Now, the first bullet point on this slide is just taken directly from a presentation that I quite often give to students when I'm talking about the appeal of law, to say that law is not professional training. A law degree is not vocational training to become a lawyer. Law is about asking questions about the world around us and the role that law plays, the role that law plays in regulating society, in navigating the complicated decisions that society has to face. And as such, law certainly can be international, comparative, sociological, historiological. Law, the way I often describe the study of law is that when students study law, they are effectively studying society through the lens of law. I think quite often for students who haven't considered law as a degree choice, they will often think that a law degree is simply training to be a lawyer. It's a vocational training course where you are training to be one of those people that you see on TV or in the movies standing up in courtroom with a wig on. And whilst that is one possible career outcome, that's certainly not a good description of the many benefits that law has to offer. And really, I would say that anyone who is interested in the world around them, anyone who's interested in asking questions about why society is as it is, would be interested in studying law. The reason I think this is relevant to our session today is because this opens law as a degree path to students from many different subject backgrounds. Really, students who would be the right student to study law, or who might be interested in studying law, are a wonderfully broad range. Students who are studying a variety of arts, humanities and social sciences subjects at A-level or BTEC will probably find that law, if they're interested in some of what those current subjects have to offer them, if they're interested in the interpretation and analysis that their subjects allow them to undertake, they will enjoy the study of law. Law is not just a subject for people who want to become lawyers. So, just really closing this section, I wanted just to turn to the content of the law degree and say a little more about what students can expect if they choose to study law at university. Now, I mentioned earlier that qualifying law degrees, as most law degrees are currently overseen, really, and validated by the legal profession. And qualifying law degrees, therefore, contain a backbone of legal knowledge called the foundations of legal knowledge. And so wherever students choose to study law, they will find these foundations of legal knowledge a core part of their degree. Now, the foundations of legal knowledge are there for a reason. They are the foundations of much of the other areas of law that students can choose to study, often as a latter part of their degree. These foundations of legal knowledge are not always called what you see here on the screen. Quite often, for example, public law could be called constitutional law. Contract law, tort law can sometimes be put together and called the law of obligations. Land law is sometimes property law. But these core areas of law will form part of every qualifying law degree, and they will often be at least 50% of that degree. So the foundations of legal knowledge are really core to the content of any law degree. Now, law degrees offer a lot more than just this foundational legal knowledge. They do offer the opportunity to develop practical skills, and most law schools now will offer students the opportunity to develop their practical legal skills either in a theoretical setting or sometimes in a real-life setting. For example, mooting gives students the opportunity to act as legal advocates, as barristers in an appeal court setting. That won't be something they'll be undertaking as real advocates, but it's often a simulation that universities make as realistic as possible. For example, at the law school at the University of Kent, we get local judges judge our moots, and that's not uncommon. Universities, law schools quite often offer opportunities such as client interviewing, mediation clinics, negotiation, all of which give students the opportunity to develop increasingly important skills for legal practice. So in addition and beyond this, law schools can also offer students the opportunity to make a meaningful contribution to society whilst they're studying. Through primarily things like law clinics, mediation clinics and innocence projects. They're some of the examples you may have heard of. Now, the law school at Kent has one of the oldest law clinics in the UK, and the clinic um, is staffed by qualified lawyers who are part of law school staff, and it allows students to get involved in legal practice, with the clinic taking on real cases from real members of the local population who need advice and representation, wouldn't get legal aid and wouldn't otherwise have access to justice. And so by working in the clinic, students can have an opportunity to get involved in law in a very practical sense, but in doing so, to develop their or to think about law in a different way. All of these opportunities listed here, clinics, projects, which often are set up to review. Innocence projects are very common. They're a North American import, effectively, which allows students to review the convictions of often people who've been convicted of a criminal offence who claim they're innocent. All of these give students the opportunity to analyse the law in a different way. They aren't just about gaining practical skills, they're about thinking about the law that they're learning in class and applying it in practice. So in addition to that, and really coming back to the first point on this slide, in addition to the co-curricular opportunities that students often have and the foundations of legal knowledge, students will also get a varied range of optional modules as part of their degree. And these can vary hugely, and there can be some really interesting examples of optional modules available at different universities. Now, quite often students will be interested in subjects like family law, international law, which are wonderfully interesting subjects in and of themselves, but they won't necessarily have thought about the whole range of options available. And I've just listed some of the optional modules which are particularly interesting or different that students can often discover as part of their degree, and which give them another perspective on the application of law to the world that we live in. So this really broadly is what students can expect from their degree. And as I said earlier, this will be useful both if they intend a career in practice or if they're studying law just because it's a wonderfully interesting subject to study. Now, that's really the end of this section of the presentation, the secondary section, where I hope to give you a broad overview of the law degree and its benefits. I'm going to move on now to the primary substance of the presentation about navigating the admissions process, the application process. Now, much of this, I think, given the backgrounds that you have from the poll at the beginning, is going to be familiar. Some of it will be very familiar. Some of it, hopefully, will be new and useful insight. Again, beyond the content of what I say here in the webinar, if there's anything you'd like to ask as a result, or if you have questions that I don't answer during the course of the webinar, I'd certainly encourage you to ask them when we seek questions at the end. Now, this slide is one that I'm sure will be familiar to most, if not all of you. This is really just an overview of the UCAS process. So students apply to study law through UCAS. They make a choice of up to 5 courses or universities, and a UCAS application will include basic information, qualifications completed and yet to be completed, a personal statement written by the applicant, and a reference, usually written by someone from the school or college. It's an academic reference that universities will expect, along with predicted grades. Now, particular points to be mindful of when advising students at this early stage, again, these are fairly straightforward points. The entry requirements that different institutions have, UCAS deadlines. There are particular deadlines associated with the UCAS process, all of which are listed on the UCAS website under their key dates section. The primary deadlines being the 15th of October Oxbridge deadline and the January 15th initial UCAS deadline, after which universities can close entry should they wish. And another thing to consider is whether the LNAT is required. Now, if we just move on to the next slide, we're going to cover that a little more now. Now, the LNAT, which stands for the National Admissions Test for Law, so you have to rearrange the letters slightly to come up with the meaning. I think actually that the naming convention is after the North American LSAT. The LNAT is a test, a 2.25 hour long test, which is used by some universities as part of their assessment process to give them more information to make an assessment on candidates who have made an application to study with them. And it's comprised of two sections: a multiple choice section, which takes up the bulk of the test, and an essay section. Now, it's only required by a small number of UK-based universities, and at this point I want to turn to our second poll and ask to see whether you can identify which of the universities that should be listed on your screen now require the LNAT.
Oh, sorry, I made a mistake. So it's only allowing you to pick one, but there's no one.
So I think there's been a slight error in the poll, and it's only giving you the opportunity to choose one choice rather than as many as you want. So I'll happily give you all full marks on this one. Okay, I think most of you have voted, so I will put you out of your agony now. The universities who require the LNAT are actually these listed universities. Whoops, let me just go back on it. The universities that you now see revealed on your screen here. From the list you were given, Kent and Warwick aren't on that list. And the reason I wanted to give you this poll, as well as showing you this list, is to really convey that the number of universities who require the LNAT is actually rather small. I think quite often there's an assumption amongst applicants that the LNAT is perhaps more widely required than it actually is. There are actually only the 8 universities that you see in front of you who actually require students to take the LNAT, or applicants I should say, to take the LNAT as part of the admissions process. Now, a question I'm often asked by applicants is, I'm taking the LNAT in connection with another one of my university choices. Does that matter to you? Kent, as you'll see, doesn't require the LNAT. Well, the answer is that whilst universities that require the LNAT get sent applicants' results directly, universities which don't require the LNAT don't get sent the results. And I'm sure that others who don't require the LNAT will share the University of Kent's view that we don't require the LNAT, and we don't ask applicants for LNAT results if they've taken the test, nor would we give the results any particular weight or any weight if we were to receive them, given that it's not something we require. So the LNAT is not particularly widespread. A number of students will take it if they're applying, certainly if they're applying to one of these university choices, but it is not as widespread as applicants often think. The University of Cambridge has its own admissions test. It may surprise you not to see it on this list here. They have their own independently crafted admissions test after previously being part of the LNAT, and I think they stopped requiring the LNAT in 2009. A university that you may be expecting to see on this list who aren't there are the University of Birmingham, who did previously require the LNAT but stopped requiring it as of, I think it was last year. So these are the universities who require it, and that's a broad introduction to what the LNAT is. Now, the LNAT is used, as I say, as a tool by universities, as another piece of evidence to make decisions about admissions. And there's a statement you can see here from the University of Oxford about the way that they use it. If we just go on, you'll see just some examples that I've taken from the LNAT website, just to give you a better sense of what the LNAT test looks like. This is an example of one of the multiple choice questions, and on the next slide we see some example essay questions, and you'll see there are a couple of answers linked, and again all of these are from the LNAT website, so well worth checking out yourselves if you are advising students who are going to apply to one of those universities where the LNAT is required. I haven't added it here, but I should say that the deadlines around taking the LNAT are also very important. It's important that students register for and take the LNAT before the application deadline for the universities that they're applying to. Again, more information about that is available on the LNAT website and will be available from law schools which require the LNAT, but it's important to be aware of which universities require the LNAT and, as I say, the deadlines for students who are applying to them. Moving back now to the the admissions process in general, to say a little more about what law schools, what the universities are looking for. This is actually a summary that I put together some time ago from a statement which is no longer on the University of Oxford website, but I thought was rather good as a description of what law schools and universities are looking for. With the first section there, talking about really pulling out the particular points which universities are, which law schools are looking for and looking to identify as part of applications. And the second part, how we look to identify those characteristics. Now, I've highlighted intellectual curiosity for a particular reason. Whilst many of the other the other characteristics listed under the evidence of section are those which we can infer from other parts of the application. So, for example, students who are achieving well academically are likely to be motivated with the capacity for sustained academic work. Intellectual curiosity is something that we see most directly in the personal statement, and it's a particularly important part of it. But all of these points are important, I would suggest, to the assessment process that every university, every law school makes when it's making an assessment. A final point on this slide is to say that interviews are rare for law. If applicants are applying to Oxford or Cambridge, interviews are expected really for all subjects, but for the most part, law is a degree programme which doesn't require interviews. Again, with your experience, I'm sure for most of you of advising students who are applying for law at university, you'll have found that offers are generally provided without interview. Generally, I would suggest that outside of the most competitive universities, interviews are probably going to be most common where law schools will have questions about an applicant that they feel would require addressing in an interview, even though they are interested enough in the candidate to invite them to interview. Or sometimes if there is a course which is particularly popular, an interview may be required. But I'm afraid I don't have figures on the number of applicants who are called for interview for law, but the number will be very small. Most offers will be made just by review of the UCAS application. Now, it's very unusual for law schools, for universities really, to quantify their assessment of applications, but it is occasionally made available, and the University of Bristol in their undergraduate admission statement for law are a useful example. On that admission statement, they quantify in percentage terms the proportion of assessment that they give to these four aspects of the application. And as you'll remember and see here, Bristol are one of the law schools who require the LNAT. Now, you'll also notice that I haven't revealed these immediately, and I'm going to now turn to our next poll to ask if you can try to, if you can correctly identify the percentage weighting that the University of Bristol Law School give to A-levels or their equivalent in their assessment of an applicant's UCAS form. Okay, again, thank you to everyone for voting. Just for the benefit of everyone who is participating, I don't think you can see the results. 43% of you chose 50%, 43% chose 30%, 14% chose 40%. If we go back to the presentation, we can reveal the answers. Congratulations to the 14% of you that chose 40%. I'm very interested to see that 43% of you chose 50%. Obviously, A-levels are not the only form of academic assessment listed amongst these criteria. And I really wanted to show this to you to illustrate the importance of academic achievement to law schools in the decisions that they make. And whilst at Kent, for example, we don't give the same quantification, I think I would agree broadly with the weighting that Bristol have given here. Certainly the importance they've given to A-levels. Quite often when applicants are asking me similar questions about the importance of their A-levels. I will liken the admissions process to a hurdles race, and to say that the predicted grades in particular, which universities will often base their assessment of an applicant's potential upon, as predicted grades are the biggest hurdle that an applicant must jump. Now, I think I might, again, this is very, this is not, again, this is an example where different universities may take different perspectives. I think there are certainly some instances where the personal statement and reference can form a much greater part of the assessment of an applicant. But I think it's important to note that the grades provide an objective baseline that universities and law schools used to sort of fairly compare applicants and to make decisions, aided by personal statements and references and other forms of information such as the LNAT, particularly where courses are particularly competitive, or where applicants are perhaps, the predictions of applicants are slightly under the level that the universities require. What I would like to emphasise from this is that although as an objective baseline, A-levels or their equivalent are considered generally by law schools as the most important factor in an assessment of an applicant, I wouldn't want to undervalue the importance of the personal statement and the reference. And again, just coming back to something I just said, really, there are particular circumstances where the personal statement and the reference can take on magnified importance. As I say, particularly where an applicant's predicted grades are slightly below the level required by an institution, where perhaps their predicted grades are strong, but the prior academic record is not as strong as is hoped. The personal statement and reference, the assessment that you make of the applicants that you're advising, and the personal statement that applicants write, can take on much greater importance than is, I think, illustrated by the figures here. But hopefully that gives you a useful and indicative overview of the assessment, of the way that universities and law schools will make an assessment. Now, just moving on to some common questions that I'm asked, and to talk a little about the qualifications that are required, I would really emphasise that students come to study law with a wide variety of qualifications, not just having studied A-levels or the International Baccalaureate. Students come to study law with BTECs, with access to HE qualifications, and with a wide variety of European and international qualifications. And again, law is a very international subject, and quite often students who will have studied it won't have any experience of studying law prior to starting the study of law at university. I'm actually going, a question I'm often asked, a question I'm certainly less often asked now than I was 5 years ago, or certainly 10 years ago, is studying law at school or college a disadvantage? But I want to turn to you to ask this question of you. So we'll just open our next poll now. Oops, no, that's not me. Have we not got that one as a...
Which one?
Oh, sorry, have I? Okay. Sorry, I'm sorry. I realise. Sorry, this isn't going to. Sorry, we're not turning to a poll after all. Let's just reveal the answer. I was going to ask you to do a hands up here. So this is, apologies for the confusion. I'm not going to ask you to do a hands up now, seeing as you have the answer directly in front of you. I think it's it used to be a long-held view, myth, that studying A-level law, certainly at school or college, was a disadvantage to applicants. I think that myth has been largely dispelled now, and I've included a statement here from the Law School of the University of Oxford stating that very clearly. Certainly, insofar as we've considered this at the Law School at the University of Kent, we feel that there is great advantage to students having studied law at A-level, at BTEC, to give them some sense of what the study of law academically is like. Law is often a subject that students won't encounter in any direct way at school or college, and where they have the opportunity to study it, it's something that can be extremely useful and revealing for them, and we certainly wouldn't seek to hold that against them. If they gain an interest from studying law at A level or BTEC, that's only to the good. And I think that it's fair to say that this view will be held by the majority, if not all, law schools now, and the myth of the A level in law being a disadvantage no longer holds true. So it is the case, however, that some law schools will require or will recommend that students take particular subjects if they wish to study law. Now, the Russell Group of universities publish a very useful publication, which I would encourage you all to read if you haven't already. If you advise Russell students who are intending to apply to Russell Group universities, called their Informed Choices publication. Now, this includes a wide range of advice about the application process and about what the Russell Group expect, but it includes within a description of what they call facilitating subjects. Now I'm going to turn to the poll now, our next poll, to ask you if you can correctly identify which of the choices that you should now see in front of you. I think we've had another technical issue with the poll here. I think this is only going to allow you to choose one rather than all that apply. So feel welcome to choose any one of those that you feel could be a facilitating subject. Okay, thanks everyone for voting, and just for the benefit of you all listening, 38% of you chose mathematics, 38% English literature, and 25% languages. Now the answer is all of them. You should now be able to see the full list in front of you. And in the Informed Choices publication, you'll see a number of examples of how the of subject profiles where the Russell Group will suggest whether facilitating subjects can be an advantage or not. And here is the description for law, where they say that, as you'll see there, that there are no, that history can be useful, as can other facilitating subjects. Now, what I want to emphasize here are two things. One is that it's important for applicants to be aware of whether the law school to which they're intending to apply has a notion of preferred subjects, facilitating subjects, or subjects which they will not take into consideration. And I also want to emphasize the view that is taken by Kent and is taken, I think, by a number of law schools, and that is that there are no particular subjects which are required for the study of law. Now, coming back to what I said in the first half of the presentation, law allows students to study the world around them, and really every subject that students can study at sixth form will give them the opportunity to do that, whether it is one of the facilitating subjects listed there, whether it's one of the highly academic subjects that's not listed there, such as politics, is very, very relevant, sociology, another one, or whether it's a subject which does not appear to be directly related. All pre-university courses will give students the opportunity not just to learn the factual information about their subject, but to think about the contextual creation or operation of the content that they're learning. And as such, I think that there are a large number of law schools that see all subjects as useful preparation, given the breadth of thought that students need to have and apply as law students. However, that isn't always the view, and again, just coming back to the previous warning, it's worth students just ensuring that they're aware of what their university choices require or don't accept. And this is just from the University of Southampton website, where they give their requirements for law, and you can see in the second half of that description, there are quite a number of subjects which the University of Southampton won't take into consideration when considering applicants to law. So certainly you'll find that universities, law schools are perhaps more open-minded than you would expect. There aren't required subjects to study law, but some law schools will state preferred subjects, and some will say that there are particular subjects that they don't take into consideration. Again, research here is the key. Now, moving on to as we move towards the latter part of the this presentation, I just wanted to really only touch briefly on the personal statement. Now, the reason I want to just touch briefly on this is there is a previous Southern Colleges Network webinar, which I've linked to here on this subject, which is very good. It builds upon Sutton Trust research that again I've linked to here to try to provide a comprehensive analysis of the position that universities take towards the content of personal statements. And having watched it, I think that the advice is broadly very good. I think that the webinar is offered by the widening participation team at the University of Gloucestershire. I'd certainly recommend checking it out. Now, the other reason I don't want to go into this a great deal, despite this being a question I'm often asked by applicants, what can I put in my personal statement? What should I include? What shouldn't I include? There is a well-established framework that I'm sure you're all giving to students that serves students very well in including all of the information broadly that law schools like to see. Their interest in the subject, any particular experience that they have in the field, any experience that they have, any clubs or societies that they've been part of at school or college that are directly relevant to law or are not relevant to them, and any interests or experiences that students feel are particularly important outside of school or college. Now, what I would emphasise really, rather than saying to you what students should put in their personal statement, I would say that the most important thing to emphasise is to ensure that the framework doesn't stifle the creativity of the student. I said earlier that what we're looking for is intellectual curiosity in an application, and the difficulty with the framework approach is that it can sometimes lead to students taking a slightly tick box approach to their application and their personal statement. So I would emphasise above everything else that whilst using the very sensibly applied framework, it still gives students the scope to be creative and to talk specifically in an evidenced way about how their interest in law has developed, why they are interested in law and how that interest has developed. And that should be a personal statement. It should be why they are interested in law. It's not just generally about why law is interesting. Again, I would add it's not a job application. Universities, law schools can often really infer some of the skills that students have got through their academic studies to date. We don't always need them to be stated explicitly. I think a very important one that I would look to state here is that students can often think that work experience can give them a particular advantage in the application process, and I think most, if not all, law schools will agree that that simply isn't true. Work experience is one way of many of students evidencing their interest in law. It is no better, it is no worse than every other way that students can do so. It is just another way that they can demonstrate to us that they are genuinely interested in law, and to talk about how that interest in law has developed. The final point on this slide, what should I put in my personal statement if I apply for 2 different subjects? I think this rarely happens. What more commonly will come up is that students say apply for law at 4 of their choices and say law and business at the 5th choice. Now, again, there's no one answer to this. I would suggest that students ask their university choices what view what their position is on this. But universities, law schools generally take a common sense approach to this. Certainly at Kent, if someone were applying for law and business with us, but they were just applying for law at their other choices, we wouldn't expect them to add in a section about business in their personal statement. If we felt that that information was needed and wasn't included in the statement, we would ask them for it. So this is something that I think I just wanted to include, just to really bring out the fact that universities are looking at making fair and equal but genuine assessments of applicants. We're not trying to catch people out. Moving on, really, this is the penultimate slide, to the reference. You'll see that I haven't really included very much here at all, and I'm very happy to say more about this, but I didn't want to include a great deal here because I'm very mindful, having again read many hundreds of these over the years, that schools and colleges do an excellent job of writing meaningful references that we genuinely appreciate and really give considerable weight to. The only piece of advice I would give is, and certainly this isn't universal, but again, coming back to the point I just made about the personal statement, universities, law schools are looking at making genuine assessments of applicants' academic potential and ability. And if there's something that needs explaining in a candidate's academic record, and if there is a genuine reason for anything that needs explaining, it is better for that explanation to be given than for a question mark to be left with the university. Sometimes, for example, I will see applicants with predicted grades which are much higher than achieved AS level grades, for example, and that will always invite the question as to why, and there can be very good reasons for that. It could be that students are developing, it could be that the transition to sixth form could have been more difficult than the student expected, and the higher predicted grades could reveal the academic progress and potential which the student is really starting to develop and show. But left unanswered, that question could be one which invites interpretation. So most, I would say, schools and colleges are very good at explaining anything that needs explaining, but don't feel that the best approach is to leave anything unexplained and hope that it isn't noticed. I'm sure that none of you do that, but again, we really want to have all relevant information to make a fair and objective assessment of a candidate as is possible. Now, very finally, just closing with a little bit of humour, this slide is really just to give you real personal statement 101 advice that paying attention to detail is important. Many students every year will choose classic pieces of literature to illustrate their interest in law and how that's developed. And To Kill a Mockingbird is one that I commonly see, and it's one that we like to see. But every year I'll see usually at least one, quite often two or three people actually say that they were particularly inspired by How to Kill a Mockingbird. Which I'm sure is a very different text. So there we are. That's the end of this webinar. I hope it's been useful. I hope it's given you some useful insight into the admissions process. Now, I said that we would have the opportunity for questions at the end, and I'd like to invite them now. We have had one question during the course of the seminar, which I'll use to get us started. And I'll just read that question out for all of you before answering it. The question is, which BTEC subjects would be acceptable for law, and would a law degree be a different style of learning for them? If so, would they adjust to it? Well, there are a number of questions there, and just to take the first question, which BTEC subjects would be acceptable for law? Again, I think this is a decision that will perhaps vary by law school and by university. So there's, I'm afraid, no shorthand to asking universities themselves. Now, at the law school at the University of Kent, we take the view generally. Now, actually, I'll just to take a step back and say, we talk about BTEC subjects. Now, students, it can be many different things to do a BTEC. It can be that students are doing a BTEC, which is the equivalent of 3 A-levels. Students may be doing 3 individual BTEC subjects, which are the equivalent of 3 A-levels. Students could be doing BTECs alongside A-levels. Now, generally, we would take the view that certainly be an acceptable subject as well. But we would certainly be open to, we are open to considering applicants who are taking other BTEC subjects. And in those situations, we may pay more attention to the personal statement and the reference of the applicant. But as with A-levels, we don't set at Kent particular subjects, and so we're quite open-minded about the background of applicants. Now, again, this is a position, the position of different institutions may vary, and there's no easy answer to this. I think that I would suggest that applicants ask this question of individual law schools. Would a law degree be a different style of learning? Now, I think there are a number of possible differences, one of which being the method of assessment, where knowing that the BTEC has been revised, but under the old BTEC structure, with law at university is different in the way that most subjects at university are different, because they invariably include end of year or mid-year examinations. Now, adjustment is, again, the question of would BTEC students adjust to the study of law at university? It could be a broader question that could be the subject of another very interesting webinar. I think it's certainly true to say that universities are increasingly aware of the different academic backgrounds of their students and are very good at supporting students to succeed in a variety of different ways. Different students, regardless of the qualifications that they enter with, will come with different strengths and weaknesses. And I wouldn't like to pick out BTEC students as a group that would be particularly, that could have the potential for being particularly weak. I think that this is that's too much of a generalization. The BTEC qualifications are obviously equivalent qualifications to A-levels and IBs, and they give sufficient academic content, we feel, as do most law schools and university, to enable students to transition successfully to the study of law. But we at Kent, as is the case with, I'm sure, all universities, will help support all students, regardless of any needs that they have based on their academic background, to transition successfully and to achieve as well as possible. So really, I would say that with increasing numbers of students taking BTEC qualifications, I would certainly only encourage BTEC students to think about studying law at university. And even though there might be differences in the way that they'll study, they are certainly not insurmountable differences. Okay, I'm just having a look at another question that we have here. Okay, so there's a question about how students do a vocational year. This, I think, is in relation to the increasing possibility of sandwich years, which are available at certain universities. And usually, where students have the opportunity to do a year's work experience, that will be integrated into the degree, making it 4 years rather than 3. I know, for example, I think it's Queen Mary created a rather useful and innovative 4-year program with a year's experience fairly recently, but they are one of a number of universities who do so. But those opportunities are integrated into the degree. Now, most law schools are extremely well networked with the professions and may offer students other opportunities to go into to experience some form of legal practice. Now, those can be through shorter placements with employers, which can wouldn't form part of the degree, but could be undertaken by students during during the course of an academic year. And then there are opportunities like the mediation clinic that I mentioned, or law clinics, which tend to run in parallel to the degree and can sometimes be integrated into certain modules, or can themselves be standalone modules which can be chosen by students as part of their degree. Okay, I think that's all of the questions that we have. If you do have any questions beyond today, you have Vanessa's email here, and Vanessa has been aiding me very ably throughout this webinar. So please feel very welcome to email Vanessa with any questions that you have. She will forward them to me, and I will be happy to address them directly. Thank you all for joining us today. Please stay on after we close the webinar. We're just going to ask you 3 short multiple choice questions to help us evaluate the webinar. Thanks again, and enjoy the rest of your day.